Buckle up, folks. This is not your average arraignment. We're watching a man face not one, not two, but three second-degree murder charges, plus 2 aggravated battery counts. This isn't just a bad day in court. This is a potential life-changing moment for Tyler James Belair, who appears remotely from a detention center in Kansas. What's wild? The prosecution says this all stems from a severe traffic incident. But Tyler? He claims it was just a car accident, totally unintentional. The judge isn't buying it though, and you'll see why. In this video, we're breaking down the courtroom drama, the legal implications, and Tyler's desperate attempt to explain away accusations that could land him in prison for decades. From accusations of fleeing the state to $1 million bond, a newborn baby caught in the middle, this case has it all. Stay locked in because we're just getting started.
All right, another individual's become seated at the detention center Zoom location. Who do I have?
My name's Tyler Beauclair, sir, Your Honor.
Very well. This time, the court will call the case of State of Kansas versus Tyler James Beauclair, case number 2025 CR 303. Darren DeVinny, Butler County Attorney, appears for the state. Tyler James Beauclair appears in custody at the Butler County Detention Center Zoom location. Do you have a copy of your charging document before you, Mr. Beauclair?
Let's pause. Here 3 counts of second-degree murder. That's rare. Typically, multiple charges mean either multiple victims or multiple legal theories. The key word here is second degree, which in Kansas implies intentional but not premeditated killing or extreme recklessness. The 2 aggravated battery charges show this wasn't a simple fender bender. This is already shaping up to be a high-stakes case with serious consequences, and the judge knows it.
No, Your Honor.
Then I will inform you in count 1, there is a charge of murder in the second degree, a level 2 person felony. Count 2, murder in the second degree, a level 2 person felony. Count 3, murder in the second degree, a level 2 person felony. Count 4, aggravated battery, a level 5 person felony. Count 5, aggravated battery, a level 5 person felony. Since these are serious felonies that are charged in this case, Mr. Beauclair, you will not be asked to plead today. Rather, a preliminary hearing scheduling will be made before your assigned judge.
Notice how the judge doesn't even ask for a plea today. That's standard in felony cases this early, especially when multiple homicide charges are involved. What's more important right now? Who's presiding? Judge Charles M. Hart has this on his docket next. And if you know Kansas courtrooms, you know Judge Hart doesn't play around.
The Honorable Charles M. Hart has been assigned this case. Your next appearance will be before that judge. Judge Hart's next docket would be August 27, 2025 at 2:30 p.m. Your case will be on that docket at that time before Judge Hart. August 27, 2:30 p.m. Mr. Beauclair, do you have the financial resources to hire your own lawyer?
At this time, Your Honor, yes. Just me being apprehended, I haven't been able to proceed with that, but I will be shortly. Yes, Your Honor.
All right, and I don't doubt that, Mr. Beauclair.
The moment Tyler says he might hire a lawyer, the judge cuts in and assigns one anyway. That's protection, not punishment. When you're facing murder charges, walking into court without legal representation isn't just foolish, it's dangerous. Judge appoints James Watts, but leaves the door open for private counsel. Smart move. Judges don't want excuses later, like I didn't know what to do. Not in a case like this.
However, in an abundance of caution, this court's going to go ahead and appoint a lawyer to represent you. These are very serious charges, quite obviously. I want to make sure that you don't go to any future court proceedings without a lawyer representing you. You certainly have the right to hire your own lawyer. And if you feel that's in your best interest, Mr. Beauclair, I encourage you to go ahead and follow through on any plans that you may have to retain your own attorney. But for now, I'm going to appoint James Watts to represent you. And again, you can replace Mr. Watts at any time with retained counsel. Do you have any questions about that, Mr. Beauclair?
No, Your Honor.
All right. So for now, James Watts will be appointed. Mr. DeVinny, I think because it's relevant to the issue of bond in this case, the court wishes to inquire. According to the state's charging document, this incident which led to these charges took place June 11 of 2025, but there's been a number of weeks go by without the defendant being brought before the court or apparently being arrested in the case. Can you explain?
Here's where things get messy. Tyler wasn't arrested right away. Why? Multiple hospitalizations, cell phone data analysis, and a long-distance trail from Kansas to Louisiana, then Indiana. This isn't some local DUI case. It's interstate, multi-agency, high investigation stuff. Also selling off property, moving out of state, disappearing for weeks. That's gonna look really bad to a judge. Whether or not it's intentional, it screams flight risk.
Sure. There were a couple. First of all, we had multiple hospitalizations. We had to gather information. I had filed an inquisition actually, and tried to receive as many reports as we could as quickly as possible. Once we received that, we also had information that the defendant had left Kansas and returned back to Louisiana, his resident state. So we tried to keep him under observation there in Louisiana while we were gathering reports and the final information. This was a severe traffic accident, required breakdowns of cell phones and car histories, as well as, like I said, collection of medical evidence with regard to intoxication, some of these other factors that are relevant to the elements of these offenses. So it did take a little bit of time. On top of that, once we had located the defendant, one of the concerns is that he had apparently sold all of his property and taken his family, and was later located outside of Indianapolis. And that's where he ultimately was arrested on that warrant. So there has been some time with regard to not just putting the paperwork together, but actually reviewing all the records and making sure that we had the elements satisfied for all of these offenses.
All right, thank you for that information, Mr. Devaney. Court notes that this is a very serious matter. 3 homicide charges, 2 potentially presumptive prison aggravated battery charges as well. The court has some information before it that would suggest that Mr. Beauclair apparently has taken steps which this court would construe as trying to abscond or to avoid capture. Therefore, the court considers him a considerable run risk and a considerable risk not to show up in court for future proceedings. The court will set bond in this case at $1 million.
$1 million bond. That's not symbolic. That's a wall. Judges set bonds based on 2 things: danger to the public and likelihood to flee, based on what the prosecutor said selling property, moving out of state, and a delay in arrest. Judge says Tyler's a considerable run risk. This bond practically guarantees Tyler stays behind bars unless he's got serious financial backing.
Cash or a professional surety required. You have a statement you wish to make, Mr. Beauclair?
And here comes the twist. Tyler's turn to speak. Watch closely. Defendants rarely make open statements at this stage, especially in felony cases, but he's about to plead for lower bond, and it gets emotional fast. You'll hear about a newborn baby, job records, GPS monitors, even offers to turn himself in. But will it matter?
Yes, Your Honor. I would like to make a statement.
Be careful about talking about your case.
Yes, Your Honor. It's only considering the bond. I was hoping to make this statement before bond was considered. Saturday, this past Saturday, I spoke with Detective Bob Albert, and all these statements of fleeing have been clarified and proven by Detective Bob Albert. Your Honor, I worked away, and I was working away in Kansas, Your Honor, and post to the accident, Your Honor, I was my wife had a due date for our newborn baby, which was 3 days away from the accident. So I did leave Kansas and head back home, and was there for the birth of my child, Your Honor. And we had actually had plans to move to Kansas prior to the accident. We were moving to Kansas, which is the reason my house and property was already sold, Your Honor. The one day after the accident happened on a Wednesday. Friday, we were actually driving back to Louisiana anyway. I was going to travel back to Louisiana anyway to finalize paperwork on the sale of my home in Louisiana, and we were moving to Wichita to move there permanently. So all the selling off property and everything, this happened prior to before I ever even arrived to Kansas. This was already happening, Your Honor. And the second thing I would like to say is it was proven this past Saturday, and I was promised by Detective Bob Albert that would have been reported to the court, but
he's pulling out all stops, says he had no intent to run, that he was just trying to be with his newborn. He claims even the detective confirmed his version, and it was all on camera. But think like a judge here. Does a planned move before the accident really cancel out the optics of leaving the state right after 3 people died? Let us know in the comments, would you believe Tyler here, or would you still see him as a flight risk?
I'm seeing now that maybe it hasn't been reported, but we called Mr. William Wonder on the spot, which is the owner of the company that I was working for, and proved that I was working in Indiana, awaiting any charges, to come against me. And then I would just simply turn myself in. We had been in contact with the Butler County Sheriff's Office and told them, if there's any charges to be against me, just give us a call, let us know. I'll just turn myself in, so I don't have to be extradited or anything like that. And we had made an attempt to find that out, and we were told that there was no information on the case that could be told to us. So I do have a wife and kids, and I was just supporting my family, Your Honor. And this has been proven. This is not speculation, Your Honor. This has been proven to Detective Bob Albert on this past Saturday, and he can attest to that. It was on camera. We called the owner of the company, and he said, "Yes, sir, Tyler Beauclair was in Indiana working, and then I was apprehended while in Indiana, Your Honor." So I am asking you to please reconsider, after hearing my statement, reconsider the bond set amount. I'm not a flight risk. I've never missed a trial. I have every intention for due process here in this case, Your Honor, and I'm very financially invested in the case as of already now. So there's no reason for me to flee. But I do have a wife and kids at home that I'm the main breadwinner for, and my wife has a newborn baby right now. He's a month old, and I just want to be able to, support my family during the due process of this case. And I have every intention to be at every trial, and I'll wear GPS monitor on my ankle or whatever could reassure the court that I would be here. We have reliable transportation for me to be here. So I just ask, Your Honor, I do have a bail bondsman already, working on this. So I would just ask that you please reconsider that, because I promise I'm not a flight risk at all. And the facts that I've offered up to you today would prove that, Your Honor.
And just like that shot down, the judge isn't swayed. Not by the baby, not by the job, not even by the GPS ankle monitor offer. Why? Because Tyler doesn't have local ties. No community roots in Kansas. That's a red flag in bond hearings. Judges want to see housing, family, jobs, in-state something anchoring you. Without that, you're a skip risk, no matter how compelling your story is.
All right. Thank you for your statement, Mr. Beauclair, but it really doesn't change the view of the court here. And I'll tell you why, Mr. Beauclair. What you've reaffirmed for the court is that you do not have established local ties. You have 3 very serious homicide charges pending against you, which any of those charges would be enough to presume that you would be in prison if convicted. So the risk is great for you not to appear. You make promises to the court that you'll do this and you'll do that. But the reality is, at this point, the court is going to stay with its original order and establish bond at $1 million, cash or professional surety required. If you feel aggrieved by this court's ruling, you can apply to the assigned judge, the Honorable Charles M. Hart, and seek relief from the assigned judge.
Yes, Your Honor.
At this point, it's $1 million, cash or professional surety required. Furthermore, Mr. Beauclair, as conditions of that bond, I will require GPS monitoring to ensure that you do not leave the state of Kansas for any reason. You're going to be confined to the state of Kansas while out on bond, and all your court appearances, unless Judge Hart orders otherwise, you are to appear at the Butler County Judicial Center in El Dorado, Kansas, for all your court proceedings, whether they're conducted by Zoom or in person. So you have to appear at the Judicial Center in El Dorado for all scheduled court appearances, unless relieved from that ruling by your assigned judge.
Let's talk conditions. Even if Tyler does somehow post that $1 million bond, he's now locked to Kansas with a GPS tracker. Any violation, bond revoked. Straight back to jail. These restrictions are aggressive but not unusual when the court sees someone as a runner. This isn't just about punishment. It's about control. It's about knowing where you are, all the time.
All right, with those orders made and conditions of bond established, Mr. Defendant, is there anything further from your perspective that we need to address here?
Your Honor, other than I did talk to Detective Albert about the interview on Saturday, and most everything that Mr. Beauclair said was relatively accurate as far as the birth of his child, and he was in Indianapolis. He was seeking employment up there, but again, doesn't really change the state's perspective of anything. I don't know that satisfies anything, but I did want to make sure that Mr. Beauclair's promises that were made by the sheriff's department to forward that information. That absolutely was done, and I spoke with Detective Albert a few hours ago.
Very well. Thank you for that statement, Mr. Defendant. All right, Mr. Beauclair, we've got your court date established with Judge Hart, and you have an appointed lawyer. If you desire to seek any relief sooner than that court date, you can work through that lawyer and file whatever motions you deem appropriate with the assistance of your attorney. I believe that's concluded all of our business here this afternoon, Mr. Beauclair.
Your Honor, could I verify one thing before I go? I would like to ask that on the charges, is it known that this was a car accident, Your Honor?
That's not stated in the charging document, no.
It is. This is a DUI. This is a DUI manslaughter charge, Your Honor.
Now this is critical. Tyler wants the court to acknowledge this was a DUI manslaughter, not murder. But prosecutors didn't charge it that way. They've gone higher, second-degree murder. That changes everything. Prosecutors may argue he showed depraved indifference or drove in a way so reckless it meets that murder threshold. It's not about whether he meant to kill, it's about the level of recklessness. And Tyler, he's clearly stunned that the court won't budge.
Well, the prosecutor's office have reviewed the facts of the case, and based on their analysis, they believe it's appropriate to file murder in the second-degree charges as a result of what happened. We're not going to get into what happened or what the facts of the case are.
Your Honor, I would just like to make it clear, Your Honor, that this is it says in the affidavit, Your Honor, that this is unintentional. This was not an intentional act. This was a car accident, Your Honor.
All right. I understand your statement to the court, Mr. Beauclair, but it's not going to change any of this court's orders made here today. If there's nothing further, then the Tyler Beauclair matter will currently be in recess. We'll move on to another matter.
And with that, the gavel drops. Tyler James Blair remains in custody, held on a $1 million bond with strict GPS monitoring. Judge Hart will see him next. This case is far from over, but what we've already seen is intense, multi-state investigations, a dramatic courtroom plea, and a judge holding the line on bond, despite emotional testimony. So what do you think? Is Tyler telling the truth? Was this just a tragic accident or something more serious? Drop your thoughts in the comments. If you found this case as shocking as we did, make sure to hit that like button, share the video, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. See you in the next one.